The stated reason for arbitration is, quote, efficiency. It's faster, cheaper, and less risk. Now, Kathy may disagree. We could probably have a whole session on whether or not arbitration is a good thing. But is it faster? 85% of cases in arbitration take as long as court proceedings. Is it cheaper? You got to pay the arbitrator, which can be $10,000 or more a day. And is there less risk? There's no judicial review. There's no appeal. The one thing it does do is it gives you confidentiality, which you can't get in a public court proceeding. And so that'd be one advantage. Judicial requirements for arbitration are it has to be procedurally fair in order to have a valid arbitration agreement, meaning it has to be signed under conditions in which it seems that it's fair, which it means it's voluntary, the person agreed to it. And if it's not procedurally fair, or the more you go down the scale of procedural fairness, you have to show substantive fairness, which means that the arbitration itself is going to be fair. You're going to have a neutral arbitrator. You're going to have discovery rights. You're going to have, so it looks like it's going to be a fair proceeding for the employee in this situation. One of the things that the courts have found is you cannot force the employee to pay more than they would have to pay if they went to court. So that means that the employer ends up paying for the arbitrator's fees, which, as we talked about previously, can be significant. And arbitration does not apply to some claims. The courts have held that PAGA claims in particular, which Kathy mentioned earlier, cannot be covered by an arbitration agreement. So the legislature passed 2 statutes this year affecting arbitration agreements. The first one is there are remedies for breach of an arbitration agreement. And what happened, the problem the legislature was trying to solve is employers were forcing employees into arbitrations. Then they would not pay the fees, because remember the employer has to pay the fees. They would not pay the fees, the arbitration goes into limbo, and the employee has no remedy. They're stuck in arbitration, and the proceeding won't continue until the employer pays the fees. So that's a problem. So basically, SB 707 was designed to apply to both consumer and employment contracts, and says that if the drafting party breaches the agreement, they waive the right to arbitration. And it also defines a breach of the agreement as failing to pay the fees within 30 days after they're required. So it was pretty clear what they were trying to solve. If the employer breaches the agreement, what happens is the employee can sue them in court, or they can continue with arbitration. We know what probably will happen is they'll sue them in court. And the court shall impose sanctions against the employer, including reasonable expenses and attorney's fees, and the court can award evidentiary or terminating sanctions, in other words, ruling in favor of the employee if this happens. AB 51 creates a ban on mandatory arbitration agreements. What does that mean? It prohibits the conditioning of employment or employment benefits or on a waiver of rights under either FEHA or the labor code, so wage and hour type things. What it does not do is it doesn't apply to common law claims, breach of contract, or wrongful termination, things like that. And it prohibits requiring an employee to opt out of arbitration. So you give them an agreement and say, hey, if you don't want to go to arbitration, check this box. You can't do that. What you can do is you can say, here's the arbitration provision. Employee, if you want to go to arbitration, check this box. And opt in is okay, and opt out is not. It does not apply to post-dispute settlement agreements. It does not apply to negotiated severance agreements. It also prohibits retaliation against an employee or an applicant for refusing to sign an arbitration agreement. And a violation creates both civil and criminal liability. It's a misdemeanor, and there's a private right of action under FEHA, including damages and attorney's fees. Now, what the statute says, it does not impact, it goes into effect January 1st, does not impact existing agreements, so long as they're not extended, modified, or created after January 1st. Governor Brown had vetoed the same bill the previous year, saying that it plainly violates federal law. Well, federal law, the Federal Arbitration Act, shows a clear preference for arbitration. The U.S. Supreme Court has basically said any state laws that violate the FAA's clear preference for arbitration are going to be invalid. And earlier this year, a New York federal court actually invalidated a New York statute, which was very similar to AB 51. Now, AB 51 contains some language in it that says it's not intended to invalidate a written agreement that's otherwise enforceable under the Federal Arbitration Act. AB 51 is going to be in court. There's considerable ambiguity in the statute. There's a possible violation of the FAA. There's a huge industry, cottage industry in California, dealing with arbitrations of these types of both consumer and employment disputes. And where do you think their agenda is going to be? It's going to be to make sure this law gets overturned. And the possible risk to you as an employer, if you have an arbitration agreement, is that you could be liable. So what are your options? Your options are: do not enter into, modify, or extend arbitration agreements after January 1st. Seems pretty simple. Limit agreements after January 1st to non-FEHA and non-labor code claims. So that means no FEHA claims, no wage and hour claims. Those are usually the ones that are most important to employers, so does that really accomplish much? You can ignore the issue and hope for the best, which, as we know in California, is probably not a good approach to running your business. Or you can revise your arbitration agreements to ensure that they're completely voluntary.